This father lost almost an entire year with his son, all because his ex secretly changed schools, lied, and cut him off from everything. Now he's fighting back in court, and the judge just dropped a shocking decision that no one saw coming. Let's break down this emotional courtroom battle.
Logan was removed from everything that he knew, everything. His friends at school, his dog, his father, his routine, his grandmother. 20 days. It will be 1 year exactly since this started. I've gotten to see my son 1 hour a week since July. He was illegally taken from me for 6 months over false accusations of a woman who was about to be exposed at work. 10 years ago when Holly had an affair, she was caught in a 1.5 year long affair with a coworker and, have her doctor boyfriend in her work, and it's all good. I don't care. She can move on. She has my blessing.
In this deeply emotional and complex custody dispute between Lucas James Maui and Holly Maui, the father, Mr. Maui, passionately explained how his ex-wife unilaterally removed their son Logan from everything he knew: his school, his friends, his dog, his father, his grandmother, who has stage 4 cancer, and his entire familia.
This man lost a year of time with his minor son after his ex-wife changed the child's school without his consent, taking the boy away from everything and everyone. And the punishment the mother received was simply ridiculous. It's impossible not to feel the father's frustration. Let's go.
Environment, in violation of their divorce agreement. Holly admitted she moved Logan from Buckley Schools to Willow Hill without Mr. Maui's consent, despite a clear stipulation in their final judgment of divorce that Logan would continue attending Buckley unless both parents agreed otherwise, reflecting their joint legal custody rights. Holly justified her actions by explaining her personal struggles. After leaving a domestic violence shelter, she needed to relocate and enroll Logan in a school closer to her new residence. She also mentioned her failed efforts to arrange reunification counseling, as required by the court, due to high costs and lack of available services. Meanwhile, Mr. Maui expressed profound grief and frustration over being restricted to only 1 hour of weekly visitation since July, describing
Maui versus Maui, taking time set for a parenting time show cause hearing as scheduled through the front of the court.
Good morning, Referee Hagan. This is Attorney Keith Kuhnman, P7456, on behalf of the plaintiff, Holly Maui.
Thank you. Ms. Maui?
Yes, Holly and Maui.
And Mr. Maui?
Yes, Lucas James Maui.
Thank you. Ms. Mullen?
Tracy Mullen on behalf of front of the court. We're here on complaints filed by Mr. Maui that Miss Maui is in violation of the default judgment of divorce, which was entered into August 11, 2023, in that she changed the minor child's school from Buckley Schools to Willow Hill without his permission or consent. He further alleges that she has failed to enroll the minor child in reunification counseling, which is also ordered as part of the judgment of divorce. 21-day notice was sent to parties on November 7th. Ms. Maui did file a response with her office, which was received on November 28th. She does acknowledge having changed the school due to a relocation on her end, which changed the school district for the minor child. Logan, I believe, is 11 years old, and on page 2 of the custody provision of the mediated agreement, final order regarding the party's minor child, contained within the judgment, it does say under number 4 that the minor child shall attend Buckley Schools unless the parties mutually agree otherwise. As far as the reunification provision under parenting time of the minor child on page 3, it indicates that the parties shall work in concert to enroll the defendant, counterplaintiff Lucas, and the minor child into reunification therapy at Kids Creek Family Counseling or Child and Family Services of Northwest Michigan if Kids Creek Family Counseling is unable to or unwilling to provide reunification therapy. It does, as part of her response, she indicates that she has reached out to in several attempts to find counseling for the minor child and Mr. Maui, but has not been successful in that. The minor child is an individual.
Describing how his bond with Logan was forcibly severed and how he has felt utterly powerless and slandered by false accusations. Despite everything, he emphasized that he only wanted to maintain a relationship with his son and have a say in Logan's upbringing, including decisions about his education, religion, and social environment, rather than remove him from his current school, which he feared might cause further disruption. The judge, After carefully reviewing the circumstances and acknowledging the father's valid grievances and emotional suffering, found Holly in contempt of court for willfully violating the custody order. The judge imposed a $300 fine on Holly, highlighting that she knowingly acted outside her legal authority by moving Logan without prior consent or a court order, which fundamentally breached the joint legal custody arrangement. However, since Logan appeared to be doing well at Willow Hill
counseling, I believe Mr. Maui was also indicated that he's in individual counseling, but those counselors are not able and or possibly willing to do reunification therapy.
The judgment also provides them with joint legal custody, correct?
Yes, Your Honor.
Okay. So, Mr. Kuhnman, anything you'd like to say on behalf of your client?
Yes, Your Honor. I will address the parenting time concern first. I think Ms. Mullen did a good job of reciting the correct provision into the record. It does say that the parties will work in concert to set up the reunification therapy. My client has contacted at least 4 places to try and set it up, the 2 that are referenced in the JOD and also Wellspring Lutheran. She also contacted Fountain Hill down in Grand Rapids recently after the 21-day show cause was issued. They agreed to take the case, but they did it with a caveat of a $6,000 retainer, which is essentially not tenable for these parties. As Ms. Mullen stated, there's 2 really conditions that have to be met: the reunification therapy and counseling by Lucas to even begin the safe haven supervised parenting time. But the parties have moved forward because it seems that the reunification provision is just not workable. So he has begun the safe haven supervised parenting time, even though the reunification therapy and his therapy, I don't know if that's been met or not. So that's where we're at. It seems like the better solution here would be either a motion to modify the judgment based on the reunification therapy being non-workable, or the parties going back to mediation to find a solution, or thirdly, just moving forward with stage 2 of the custody and parenting time order that's always in place. But there's no active will by my client here to defy the court's orders with respect to that parenting time provision. With regard to the school change, I agree with Ms. Mullen's recitation of that issue as well. The only caveat that I would add is that the timing here, what happened is my client got out of the women's domestic violence shelter that she'd been in since January. She got out in April or May. The judgment of divorce entered in August, and my representation of her ended at that time. Shortly thereafter, it was in time to enroll the child into schools. She had relocated to the Willow Hill School District, as was stated, and was no longer in the Buckley area. She had 100% of the overnights, and she didn't understand that the obligation upon her with joint legal custody. She was just trying to do her best to get back on her feet and get the child enrolled. The child is doing well at Willow Hill. He's attending counseling. I believe my client attached letters from the teachers saying that he's doing well. And I don't really think that moving the child back to Buckley is in the best interest of the minor child, pardon me. The final thing I would note in my client's defense is that there is a PPO in effect here in this matter, which does make communication between the parties difficult, especially during that intermediate period after the entry of the judgment of divorce and my representation beginning. So with all that being stated, we would impress upon the court that there was no intent to violate the court's orders. If she did so unwillingly or unknowingly, and she is apologetic for that. But ultimately, the child is in a better situation. Thank you.
And given Mr. Maui's ultimate consent to keep him there to avoid more instability, the judge decided not to force Logan's return to Buckley schools. Additionally, regarding the reunification therapy provision, the judge determined neither parent was in contempt since both had shown efforts, albeit unsuccessful, to fulfill that requirement. The judge encouraged them to move forward with the next stages of supervised parenting time and emphasized that any future significant decisions regarding Logan, including school or health care, must involve both parents and, if necessary, court approval. The judge also informed—
Thank you. Mr. Maui, anything you'd like to say or add?
We had enrolled Logan in Buckley schools for specific reasons, moral reasons, things like that. We just didn't want him in the Traverse City school district. When Miss Maui decided to leave the relationship on January 9th. The last time that I saw my son was January 8th. She removed him, Logan, everything's better for Logan. Logan was removed from everything that he knew, everything. His friends at school, his dog, his father, his routine, his grandmother. There's been nothing said here about the fact that Mrs. Maui completely removed Logan from my life, my mother's life, who has stage 4 cancer, who luckily she got to spend the last 2 weeks with Logan because she had COVID and she was at her house on oxygen. And I mean, I could go on for days, but the lawsuit, and when we do discovery, that's when all of this will come out. I sat here and I done everything that the court has asked me to do. I've not pursued Mrs. Maui. I have not even so much as asked one person if they know where she is, if they've talked to her, anything. I want nothing to do with Mrs. Maui. I have been trying to get out of this relationship for the past 3 years. And I can show records, and we will do that in discovery, on where I have quit my job. I left for 3 weeks last year. Mrs. Maui took this opportunity to build me up in order to chop me down. And before she left, I made a threat that I was going to call her boss and expose her for what she had been doing, because my mother had COVID at the house. She was not testing, and she was going into work at Thurlby Clinic, putting people in danger. And I said that because I was mad, because Mrs. Maui and me were fighting. She'd become angrier and angrier as the days went on. And now I have also heard through other people, my friends, that she went and did a slander campaign on. Mrs. Maui expected me to commit. And when I didn't, she went on a slander campaign. And during the slander campaign, she didn't figure that Luke would ever make it back out of that house. Well, through counseling, through just wanting my son in my life, I don't care about anything else. I want Logan. That is my son. I love him. I have never abused him. And my mind's just spun here. In 20 days, it will be 1 year exactly since this started. I've gotten to see my son 1 hour a week since July. He was illegally taken from me for 6 months over false accusations of a woman who was about to be exposed at work. And I shouldn't have threatened her. I shouldn't have, but I did. And Mrs. Maui decided to show her true colors, because this is not the first time that this has happened, sir. I believe that I spoke to you and Mrs. Your Honor Witten 10 years ago when Holly had an affair. She was caught in a 1.5 year long affair with a coworker, and her coworker put a PPO out on me.
All right, so some of this, let's start to get. I'm going to have to rein some of this in.
I'm sorry.
How does it relate to the what's going on with reunification counseling? I mean, I don't want to totally cut you off, but 10 years
right?
ago,
No, I know. I could, like I said, I could go on for hours. I'm sorry.
I was in a totally different county 10 years ago.
I know. Okay, but I have no communication with her, sir. And I did also write to you to try and get the PPO removed. I know that it was past the 2 weeks. I never tried to get the PPO removed because I never wanted to talk to Mrs. Maui again. I wanted to communicate through Wizard or whatever in order to co-raise our child, and she can go and do better and you know, have her doctor boyfriend in her work, and it's all good. I don't care. She can move on. She has my blessing. I just want my son. I haven't done anything to him. I haven't.
So, let me ask you this. Are you comfortable then proceeding to the next stage in the judgment?
100%.
Okay, so we're good with that. You're progressing in the steps, correct? I mean, part of the issue here, I can say, I have some concerns because I don't believe that CFS even offers reunification therapy. So
they don't.
That's in the judgment. I mean, there's nothing we can do about that now. So I don't know if the two of you need to modify the judgment, or if you're willing to just move forward with the steps, let's just head there. For enforcement purposes, I don't know that either of you are doing anything wrong in terms of contempt for the reunification therapy. So for that aspect of this hearing, I'm not going to find Ms. Maui in contempt. And I would recommend that you continue to move forward. If you feel like you want that provision changed, you'll have to seek other relief. But in terms of contempt, I don't believe that she's in contempt there. It sounds like she's made efforts, that both of you are progressing. You're in counseling, sir. You're having the visits. So we're doing well there. The issue with schools, though, what are you wanting as your remedy there?
What is that? I want this person to quit acting like I died. I am this boy's father.
Right.
And I want to say in his religion, his schooling, the people that he is around. My son came to a visitation the other day and told him that a person, he wouldn't tell me because his mother's instructed him to lie about who he's around. They stuck a 12-gauge shotgun in an 8-year-old's hand and let him shoot it while she sat there and videotaped it. Now I'm sitting here getting accused of threatening Mrs. Maui with guns, which I have never done. I got Mrs. Maui her CPL. I taught her how to shoot. I have taught my sons gun safety since they were old enough to recognize what a gun was. And I have sit here and I have been badgered. I have just been slandered to the point where it's almost no recovery. The only thing I have left is the lawsuit. Are you
wanting your child to be returned to Buckley schools?
At this point, it doesn't even, what's it matter? Now I'm doing more damage, right?
Well, I don't know.
You
filed the complaint. I'm looking for what you want. She's in contempt of the order. That is a finding I'm making. So on the school issue, I don't buy that she didn't understand the joint legal. And then not only that, but it's spelled out in paragraph 4. So you all specifically stated you wanted it to be sometimes people say, well, I didn't know what joint legal custody is, I guess, but I don't believe that's the case here. And it's you can't deny that you all agreed that Buckley Schools was going to be the school. My question is, are you I'll get to a consequence in a second. She's in contempt for sure on that issue. But what are you wanting as your remedy for the school?
I want to be able to talk to the people that are educating my child. I don't think it's fair in any way.
Do you want him removed? Do you want him placed back in Buckley Schools is what I'm asking. No,
I don't want him placed back in Buckley Schools.
All right. So, ma'am, I do find that you understood the order. I believe that you willfully violated the order. It's really hard for me to imagine that you didn't know when you specifically agreed that Buckley Schools was going to be the school, and then you moved the child without seeking any type of consent with Mr. Maui. You could have had a hearing. We could have gone over this. It's too bad the child's doing, I shouldn't say it's too bad. What I was going to say, it's too bad that you violated the order. It's great that the child's doing well. I'm even happier that Mr. Maui is consenting to the child remaining where he is. That's what I would prefer, or at least, we have a hearing on whether that school is appropriate. But right now, I trust Mr. Poonman that your child's doing well. So I'm going to leave the school as is. But any change from there, just remember you have joint legal custody. You're not able to do that. In terms of any type of consequence, I'm going to issue a $300 fine for violating the order. You'll have 6 months to pay that. If there's child support ordered, I'm comfortable if it's just in as a credit, so that she doesn't have to pay cash. But just remember, you have joint legal custody, and that's these types of decisions. If the two of you can't agree, you have to come to court first. I believe that you probably did that in the minor's best interest, but you have to, because the two of you don't agree, or I don't even know. There's not really any record of you even reaching out to ask Mr. Maui if that's okay. He's okay with it today, but you obviously knew that when you wanted Buckley to be put in your judgment, that was the school you wanted. So to change it was inappropriate and contemptuous. So you have the right to file an objection if you believe that the court made any errors, or if you have any issues with the court's ruling today, and then your objection would be heard by a judge. So thank you all. We'll stand adjourned.
Thank you.
Informed them that Holly could file an objection if she disagreed with the ruling. Overall, This case starkly illustrated the lasting emotional wounds and practical challenges of co-parenting after a high-conflict divorce, especially when past interpersonal betrayals and communication breakdowns deeply shape present interactions. The judge's solution aimed to balance legal enforcement with the child's best interests, holding Holly accountable while preserving Logan's current stability, and it underlined the critical importance of respecting joint custody arrangements to protect both parental rights and the child's well-being.